Liquidation of companies in Nepal. Liquidation is the formal process of bringing a business to an end and distributing its assets to claimants, such as creditors and shareholders. It is most commonly initiated when a company becomes insolvent, unable to pay debts, or faces financial hardship. This video describes about the detailed information, conditions, and process relating to the liquidation of companies in Nepal. Governing laws. First, the Insolvency Act 2006. Second, the Companies Act 2006. And third, the Bank and Financial Institution Act 2017 for banks and financial institutions. Methods of liquidation. In Nepal, there are two types of liquidation. First, voluntary liquidation. Second, compulsory or forced liquidation. Voluntary liquidation. A voluntary liquidation is a self-imposed wind-up and dissolution of a company that has been approved by its shareholders. Voluntary liquidation is done when company is able to pay its debts fully and a situation where a company can satisfy the claims of all its creditors. Conditions of voluntary liquidation. First, the company is able to pay its debts or other liabilities fully. Second, shareholders must make a written declaration regarding payments of liabilities in full. Third, shareholders must pass a resolution to liquidate the company. Procedure of voluntary liquidation. First, verifying the company's financial status to clear all of the debts and liabilities. Second, written declaration from shareholders confirming that the company can satisfy debts and other liabilities within 1 year from the date passing of resolution for liquidation or can be fully satisfied through any other arrangement. Third, written resolution by shareholders through general meeting for liquidation of company, appointment of auditor and inform Office of Company Registrar within 7 days of appointment. Fourth, Section 130 of the Companies Act provides that the liquidator shall take control over all the assets, accounts, and records of the company. Liquidator will first file information to the OCR regarding income and expenses, accounts of the companies at the interval of every 6 months, notify shareholder of the company every 6 months regarding progress of the liquidation process, discharge all the debts and liabilities of the company from the assets and receivables of the company. After discharge all of the debts and liabilities, submit the proposal for distribution of residual assets before the shareholder meeting. Make payment to the shareholder out of the residual assets if the same is approved by shareholder representing 75% of shares. Submit a report to the OCR detailing money realized from sale of assets, payment made to the creditors, and distribution made to the shareholder, including auditor's report with certification that the company has been liquidated. Fifth, liquidation of company at OCR. And the last, closure at local level, ward office and inland revenue office. Compulsory liquidation. Compulsory liquidation is a situation in which a company must stop operating and sell all its assets in order to pay its debts. Compulsory or forced liquidation is done if any company is not able to satisfy claims of all the creditors. Conditions of compulsory liquidation. This process begins with a court order, which is usually initiated by the company itself, at least 10% of its creditors, shareholders owning 5% of shares, debenture owning 5% of debentures, a government body or authorized body overseeing specific industries and business. Procedure of compulsory liquidation. First, reception of an application to the concerned court. Second, hearing an order by court to institute or not to institute insolvency proceeding. If accepted, court gives order to appoint an inquiry officer. Third, inquiry officer is appointed to inquire into insolvency proceedings and determine whether its financial institution can be improved or not to issue an order for immediate liquidation, whether an order should be issued for restructuring of the company through restructuring program or not, or whether the company is insolvent or not. Fourth, report to be made by director on financial situation and transactions of the company to the court. Fifth, the inquiry officer shall submit an inquiry report to the court within the period specified by the court. Sixth, the court shall make any of the following orders within 7 days of the receipt of the report submitted by inquiry officer. Immediately liquidate the company, implement the restructuring program, to stay until the period specified by the court in the event of the possibility without liquidating, or extend the period of insolvency proceedings. Seventh, court shall make an order to appoint liquidator if the court makes decision to liquidate the company. Eighth, liquidator will be the primary decision-making authority. The directors, officers, and all other employees are relieved from their position, and liquidator exercise all their power. Liquidator takes into custody all the assets, properties, and books of account except the properties in possession of secured creditors. Ninth, the liquidator shall prepare a progress report in relation to the company and submit it to OCR and court no later than 3 months of his or her appointment. 10th, settlement of liabilities is done following the order as prescribed in Section 57 of Insolvency Act, and for bank and financial institution according to the Bank and Financial Institutions Act. 11th, liquidator shall submit the report at the completion of liquidation proceedings to prepare a report on the properties recovered, payment made to the creditors, and distribution made to the shareholders on behalf of the company, and submit such report certifying that the company has been liquidated, accompanied by the auditor's report to the OCR. 12. Upon offer report on the liquidation of a company, OCL shall strike the name of the company register and issue an order that the registration of the company has been cancelled. Notice must be published in a national daily newspaper that such company has been dissolved. 13th, closure at local level ward office and relevant inland revenue office. Deregistration of a company in Nepal. Deregistration of a company in Nepal is possible if company has not been operated and has not done any activities after registration of company. This is only possible if company has not submitted any compliance document to the OCR, including 3-month compliance. The procedure of voluntary dissolution involves the following steps. Number 1. Passing a special resolution for deregistration of a company by its shareholders and submission of a same to OCR. Number 2. Publishing a notice of deregistration of a company in national daily newspaper. Number 3. Letter of confirmation from auditors to OCR regarding no economic activities of company. Number 4. Confirmation from Inland Revenue Department to OCR. Number 5. Deregistration of company at OCR. And number 6 and last, closure at local level ward office and relevant inland revenue office.